SJC-11823, John Doe number 380316, v. Sex Offender Registry Board.
Good morning, Chief Justice, members of the court. My name is Brandon Campbell, and I represent Doe, the petitioner. Increased accuracy so that the public receives better information about risk, sex offenders aren't misclassified, and so that law enforcement scarce resources are properly directed to where they should go. That's the short answer why this court should revisit the holding in Doe 972. And hold that the Sex Offender Registry Board must prove its case by clear and convincing evidence.
Is there a statutory provision that you have to deal with which sets forth the burden?
In Doe 972, this court ruled as a matter of the state constitution that the board must prove its case by a preponderance of the evidence. A year later, the legislature adopted that standard in the 1998 SORB.
So does that change the analysis in terms of the range of our options in terms of changing the standard because it has now been codified?
My brother argues to the contrary, but my position is that it is always for this court to determine what the minimum constitutional due process is. And that test has always been Matthews versus Eldridge. And that is the balancing of the state versus the private interests and consideration of the risk of erroneous deprivation. I would point out that when the court visited this issue in 1997, there was a process that the legislature put in place. And that process was that the Sex Offender Registry Board would give a classification level, and then it would be up to a petitioner to go to Superior Court and argue that that classification was arbitrary and capricious. I do not think that because the legislature took a cue from this court and adopted the standard that this court said was required by the Constitution, that that should change the analysis.
Can I ask you a factual question that I must say I don't understand? I learned that only 3 states have this sort of adjudicatory process of determining the levels of risk. The federal, does the federal law, it obviously doesn't require it because only 3 states have it, but so why do only 3 states do this?
Well, the Supreme
What happens
Court,
in the other states? Because every state has to have a registration system.
yes, the short answer is the states are all over the map. 35 states, there is no adjudicatory process. You are given a level based on the offense that you receive. I'd submit that those states don't have any concern for accuracy that this court and our legislature has.
Is it just considered part of the sentence that you will have? I mean, is it
in
part
some
of the
cases,
sentence?
yes. If you commit X crime, you're a sex offender, that's it. That's all there is to it. And systems like that, they're not accurate at all because that person could have some debilitating health issue and they're still a dangerous sex offender. So
that wouldn't satisfy the Matthews test?
That would not satisfy.
Other states that do that wouldn't satisfy the Matthews test?
I don't think it would satisfy the Matthews test.
But they're still out there.
They're still out there,
They
yes.
haven't been struck down as...
But they're part of the criminal sentence as you just described it, which ours isn't.
They
right?
can be.
Can be.
There is a wide difference. The Supreme Court has not addressed the issue. The Third Circuit has held that under the 14th Amendment that it must be clear and convincing evidence. And New Jersey and New York have also required clear and convincing evidence.
I'm sorry, New York and New Jersey have done so because the legislature said so or because the court said so?
Court.
I believe it was from the legislature.
No, I think it was the court.
Okay, I could be wrong on that.
Both New York and New Jersey, I think.
Be that as it may, it is clear and convincing evidence.
I'm sorry, clear and convincing to do what?
I'm sorry?
Clear and convincing evidence required to register at all?
No, to determine which tier,
Clear
what-
or tier or classification level, whatever the language may be. In the New Jersey, I believe it's tiers. New York, I believe it's levels.
So what would that mean with regard to Tier 1? Or Level 1 for us?
I believe the case is, at least, maybe there's more, but it's really about level 2 and 3 that the discussion is. I think in at least one of those states, it's automatic registration for a level 1 registration, but then the notification provisions that attach to which higher tier, that's where this comes in.
Your Honor, are you talking about New Jersey or New York or this state?
No, New Jersey, I was really
Okay.
talking about.
In
No,
Ma-
not this state, I know that.
Yes. In Massachusetts, you have to prove every level. You have to prove even a level 1.
Well, let me ask you about that. I mean, I understand that internet dissemination was not part of the statute when we ruled in Doe 972, and you say that makes it different. If that is right, would clear and convincing be required only for a level 2 and level 3 finding?
Frankly, there's an argument, yes, that because the provisions are more stringent for level 2 and level 3 offenders, that perhaps they could have. But I think that needlessly complicates it. I think a clear and convincing evidence standard works for 1, 2, and 3, not only because level 1s also have significant liberty and privacy interests, but also because it's sort of grading on a scale. It's a 1, 2, 3. If clear and convincing evidence isn't met on level 2, maybe it's met on level 3, maybe it's met on level 2. And then if it's not met on level 2, it's a lot easier to meet it on level 1. So I think that needlessly complicates it, although I would concede that there is an argument that there could be a distinction there.
What would it mean to have clear and convincing evidence that you are a low-level offender?
Well, I think it would go through the normal analysis in any case. There would be a look at the regulatory factors and the hearing examiner. What standards of review do is they ask, in this case, the hearing examiner to express a certain level of certainty in their decision. And that's all that any standard of review does, whether that's beyond a reasonable doubt or preponderance of the evidence. Clear and convincing evidence asks them to express greater certainty in their decisions. And I think if we do the Matthews test, knowing what we know now, in the balancing of the interests involved, that sex offenders and the public deserve the clear and convincing evidence standard. Now, it is not the same law that this court reviewed in 1997 because, as has been acknowledged, level 2 and level 3 offenders are now put on the internet. There are secondary address restrictions. There are institution of higher learnings those addresses must be registered. Homeless offenders must register every 30 days. I could go on and on. It is much more stringent. Yet, at the same time, given the time that's passed, we know much more about sex offender registration, sex offender registries and how they work, as well as sex offender recidivism. Though number 972 was a creature of its time, but given what we know now, I think the court would have reached a different conclusion. And the amicus brief makes a very good point of this. And with all due respect to the majority in 972, I think what happened is the court conflated the presumption of validity that's afforded to a statute with an analysis of how that statute actually impacts the interest that the legislature is trying to protect. We know now from the better part of a decade that sex offender recidivism is low, and it's much lower than most other crimes or other types of offenders. The Hansen research, Dr. Hansen, which this court has acknowledged on previous occasions as an expert, who the board has cited in its regulations, consistently finds an average of 13%. That's 87% of sex offenders not reoffending, or almost 9 in 10 of these people who are subjected to these stringent registration obligations pose no threat.
Can I just ask you, why are these considerations for the court as opposed to the legislature?
The answer is when we do the balancing test under Matthews versus Eldridge, we have to balance the state interest, we have to balance the private interest, as well as look at the risk of erroneous deprivation and the probable value of additional safeguards. And when the court has to look at the state interest, the court has to look whether the statute that the legislature has enacted really has any impact on what it's trying to remedy. And in this case, it's striking to me that we've had the SORLs in various versions for almost 20 years, and the SORB cites nothing about how effective it is, about whether or not it prevents recidivism. There is absolutely nothing that they can point to. Now, whether that justifies an adverse inference that the numbers would be unfavorable to their position, I would leave that for the court. But we can look to other states. And we know in New Jersey, New York, as well as 12 other states, the research is showing that sex offender registries are not deterring first-time offenders, and they're not having an impact on recidivism. So we can infer that the Sex Offender Registry Board that we have here, or the registration law, which is much like New Jersey and New York, that it is not having an impact. At least there is no evidence to support that it is having an impact on what the legislature is trying to remedy.
I don't mean to be too theoretical here, but all right, so we've had a sex offender registry board for 2 decades? Almost 15 years?
After 98, it was...
Yeah, all right. And so all of these offenders are registered. So how do you know whether that has had a deterrent effect or not, since they're all registered?
Easily, because the Sex Offender Registry Board knows everyone, knows what their levels are, and it's reported to them when they are
So recidivism is low. So recidivism is low, you say?
Well,
Well, maybe this is a cause and effect. Maybe because there's a registration system, the recidivism is low. I don't know.
there's absolutely no proof of that, is what I'm trying to say.
Whose burden is it to prove that this legislative program is not constitutionally functioning?
Well, I suppose the burden is mine, but still, they have to put something forward to defend their position, and they haven't done that.
Can I ask you something about the standard? If you say clear and convincing evidence, that means that the facts, I think, that the facts found are highly probably true. I mean, that's one way of saying it. I guess when you use that construct in the context of these factors, some of which are static, and I don't, there wouldn't be any dispute about them. And a lot of them are, and ultimately it's a judgment call, right? I mean, I'm just wondering what impact really in this context changing the standard of proof might have. Because it's not like, it's different from a lot of factual determinations that are straight, did this happen or didn't it?
You're right, Your Honor. It is very loose. There's a list of 24 factors that the hearing examiner applies, and there's no rules about how that hearing examiner must apply them. And then the hearing examiner assigns a level, and that is a very loose standard. And given the deference that's shown on 30A review,
Ultimately, a judgment call, right?
it is ultimately a judgment call. But I argue that precisely because of that, we should ask hearing examiners to express more confidence in their determinations by imposing a clear and convincing evidence standard. One thing I want to finish with is it's important for our position, if you look at the numbers provided by amici, if you look at Massachusetts, almost 2/3 of sex offenders are classified as level 2 and level 3, moderate and high risk. And research shows that the majority of sex offenders are on a low risk trajectory, upwards of 95%. Sex offenders are way overclassified. If you look at New York and New Jersey that uses a clear and convincing evidence standard, their numbers are more in line with what the numbers should be as shown by experts. So it does prevent misclassifications. They haven't had more sex offenses as a result of this higher classification.
How long has it been since New York and New Jersey have used the clear and convincing evidence standard? Has it always been so?
I don't know that answer. Your Honor.
I just wondered how that
The cases
intertwined with the
that
statistics.
required it were in 97 and 98.
Oh, so it's been a long time.
Yeah.
I can tell you the studies that I'm citing have looked at, I believe, the recidivism numbers. It's the late 90s.
Okay.
Because they look at the
So
numbers
these statistics
before.
that you're citing to in the amicus briefs are ones that sort of dovetail for a long period of time.
Yes, they look at before and they look at after so that they can take into account the trends, because actually trends were showing that sex offender recidivism was going down, so you have to account for that in the study. Otherwise, it would make it look like it's doing something that it's not.
No. Okay.
All right, thank you.
Thank you.
Good morning, Your Honors. Chief Justice Gantz. David Chennai for the board, if it pleases the court. I don't think you'd be surprised to find out that the board is opposed to having the standard of proof being raised or elevated in our classification procedures. The burden to come in today and explain why the burden should be raised, or the burden of proof should be raised, the burden is on the plaintiff to prove that there's a reason why, that it's either a constitutional infirmity, that it's not. And they haven't done that in their briefs. In fact, comparing New York and New Jersey to our system is like apples and oranges. New York uses clear and convincing, but if you look at the guidelines they're using, it's stacked against the offender. Now, what they have is they have 15 factors. That's what they use in the guidelines. And each factor is given a number. What the individual offender has the right to contest is the number given to that factor. And out of the 15 factors, none of those factors are factors that benefit the offender. New Jersey uses essentially the same, only they only have 13 factors they use, and they use a moderate, high, or low level, each one which has a numeric figure to it, and the offender has the right to contest whether that factor should be applied moderately, as a high factor, or a low factor.
And yet, the New Jersey and New York outcomes seem to be quite different than Massachusetts. It may start out, as you say, stacked by virtue of the factors against the offender, but the results don't seem to be as well. They strike a different balance than we have in Massachusetts, where more people are found level 2 and level 3.
Right, but if you look at the amicus brief and the studies they cited, both for SORA and the SORNA and SORC of New York and New Jersey, those studies specifically say that neither system, neither state can adequately predict sexual recidivism, that they are not putting sexual offenders in the right categories, which essentially means they're overclassifying because of the system they use. If you look at the studies, they specifically say that the offenders are not being put in the right categories. That, in fact, one of the studies specifically says SORA cannot predict which offenders will sexually recidivate
Neither
under
can
the
you.
system.
Can you?
Excuse
You think
me?
you can?
Yes. I think that Massachusetts uses, and again, Massachusetts gives more rights to sex offenders than any other state. And one thing we do is we have, first of all, we use 24 factors plus another 10 sub-factors. And the offender has the right to bring in any information that would be mitigating. And they have a right, and this is something New York and New Jersey does not allow. They have a right to contest the facts at the hearing of the actual sex offense to show there were mitigating circumstances. New York specifically says in the statute that the sex offense, as proven in court, it's been proven by clear and convincing evidence, and the statute says it shall not be litigated at a sex offender hearing.
Let me, this is unrelated to that, but you mentioned in a footnote that the legislature passed legislation this last session saying within 60 days the board had to do something about updating its regulations. Could you
Correct.
tell us where you are on that?
Well, right now, the regulations have been finished. They are now being reviewed. Once the final review is done, it's our hope to bring it straight to the Secretary of State for promulgation. I've seen them. I think the updates are based on current research.
There are public hearings on them?
There will have to be a public hearing as soon as we can get the okay from the Secretary of State, or receive it back from the, file it with the Secretary of State. The public hearing will be set up at that time. So we're close to being finished, which again puts a situation where why change the burden of proof until you've at least seen what the regulations look like? If the regulations are up to date and accurate and reflect present research, then there's really no reason that we should have to raise the burden of proof.
But the question about burden of proof, I think Mr. Campbell is correct that you're balancing the Matthews factors, right?
Correct.
So how does so you're looking at the interest of the offender?
Correct.
Pretty strong here, given all the limitations on level 2, and particularly level 2 and level 3 offenders, right?
Correct.
So there's a huge interest in not being overclassified.
Correct.
The interest of the state, now what's your view on what Mr. Campbell says in terms of what the proof is that, yes, the state has a compelling interest in protecting children and other vulnerable populations, but doesn't there have to be some indication that this way actually offers some protection?
Well, I think you got to backtrack a little bit. I think outside of the Matthews test, the issue is, and again, if you decide that we have to prove our cases by clear and convincing evidence, if you decide that, this will be the first time that an agency who is not involved, and again, up to this point, we have said that registration and notification is not a fundamental right, and not a fundamental constitutional right requiring strict scrutiny. This will be the first agency required to be given, to hold to a standard of clear and convincing on an issue that doesn't involve a fundamental constitutional right. And if you do that, are you opening up a can of worms where if I lose my license and all of a sudden now I'm asking the registry to do it by clear and convincing evidence? Because although it's not a fundamental right, it affects me deeply and it's a stigma against me.
Would a change in the standards have any practical consequences for the board in the way it does its work?
It would have an incredible sea change in the way the cases are reviewed by the Superior Court. I think if you change the standard, you're allowing Superior Court judges to basically will have to relitigate these cases in the Superior Court based on a clear and convincing evidence.
It's all on a record. You don't relitigate them. You've got a written record.
I understand that, but again, my experience is that judges have, like all individuals, different criteria for what is clear and convincing on individual cases. I think you're going to find Superior Court judges are going to analyze these cases much more closely and determine whether or not clear and convincing has been found. And up to this point, and I think you have to keep in mind...
Is that a problem?
It is a problem in the sense that the whole I guess, process is designed to effectively and as manageably as possible have sex offenders classified and put in the proper classification, and then to implement the law at that time. If you end up allowing cases to languish in the Superior Court, and then you're running the risk of the cases moving slower through the system. But most importantly, The board is designed as experts in this area. If you're allowing Superior Court judges to step in to be the experts, you're defeating the purpose of the sex offender
But
registry law.
isn't it a bit troubling that you're saying that clear and convincing would have consequence only on the Superior Court
Well, I think it
review
would
and
have
not on your
consequences
own?
all the way through the system.
How
But-
about on the
But how
board?
come you made no mention of it affecting the board's review?
Well, the board's review would be a lot harder, too. I mean, the standard of proof and what we'd have to present, I think you're heading for a situation where we're going to have to bring in experts for every case, which is something that we've, legislatively, we've been told that we don't have to do.
Let me ask you, what do you contend to be the sexual recidivism rate in Massachusetts of sex offenders?
I have no idea what the sexual recidivism rate in Massachusetts is for sex offenders.
Nationally?
Nationally, I don't know that either. I've seen many studies that say it's low. I've seen other studies that say it's high. The studies conflict on that issue.
Represent the organization which evaluates whether offenders have a moderate, high, or low risk of offending, and you are telling me that you'd have no clue what the rate of sexual recidivism is in Massachusetts or in the nation?
Well, we haven't been given the burden of proving our case or the effectiveness of the registry law.
Well, apparently 77% of sex offenders are being labeled moderate and high risk offenders.
Well, you can look at the flip side.
And if he's correct, and at least in terms of certain studies, there's a 13% rate of sexual recidivism, how do you get 77% of Massachusetts offenders being of moderate high risk of reoffense for sexual crimes when, at least nationally, only 13% are committing them?
Well, first of all, we don't concede that only 13% are committing them. What Hansen said
You
in
don't
that
concede
study,
because you say you have no clue what the numbers are, which
Well,
I
I do
find
know this.
astonishing.
Hansen says in that study where it's 13%, he specifically says you need to know, though, that there are sex offenders that are high risk, sex offenders that are moderate, and sex offenders that are low.
Of course.
And that they have to be classified in that way, which is what Massachusetts does. And what Hansen is saying is that overall it's 13%, but the high-risk ones offend at a higher level than the low-risk ones.
Of course, but
And that's what we're trying to figure out.
We
What's
have
high risk?
77% of Massachusetts offenders are being labeled as moderate and high risk, when the overall risk appears to be 13%. And I'm trying to figure out how that happens, and maybe we need to reevaluate the standard that you folks are using if we end up that way.
Well, I think what you're saying is that because we have that number as high and moderate, that somehow because the number of 13% proves that only 13% are going to reoffend,
No, I'm not saying that.
then I'm kind of confused as to what the
I
analysis...
know you have to evaluate the risk beforehand, obviously. I understand that. But it is hard to imagine that you have, well, I mean, 77% being moderate or high risk. Do you consider 13% rate to be a high risk?
I think Hansen says that it's 13% doesn't necessarily a low risk. If you have, and again, you got to look at the study itself. He is saying that there's high and moderates that offend at a very high rate and low offenders who reoffend at a very low rate, and when you average it out.
Right.
So Massachusetts is trying to set up a system where we figure out who are the high, who are the moderate, and who are the low.
Right.
And that's what we're doing here. Now, that it comes out moderate and high based on the guidelines, that's how it falls into place. It doesn't necessarily mean because 13% nationally have a reoffense rate, doesn't necessarily mean in Massachusetts that 13% holds, nor does it in any other state. Other states have seen higher rates, and other states have seen lower rates.
But you don't know
It's
anything about
demographic.
our rates.
Excuse me?
You don't know anything about our rates.
I know that. But we were not, the government hasn't put a burden on us to do that type of analysis. Our sole purpose is to classify sex offenders.
How many of the sex offenders are currently classified as moderate and high as compared to low?
Well, judging from the numbers that are, it would be 2/3 and 1/3. I believe 1/3 would be low.
That's how they break out as it happens.
No,
Correct.
well, if it's 77% are moderate and high, then
I mean,
1/3
somewhere in the
isn't
briefs
low.
it says 54% are level 2 and 23% are level 3. I don't recall precisely where that was
Right, but if you take
found.
that middle group and put it with the lower group,
Well,
then you're up to about 70% are low or moderate.
But that's, given the restrictions on moderate, I don't think that's really very fair. It seems to me you've got to take low by itself, and that is 23%.
If you have 23% and add it with the moderate, I don't think you, see, the thing is, it comes out the way it comes out. We're not trying to make sure that we have enough low to say, okay, now we have enough low offenders, so now we're okay. We're going by what the evidence puts in front of us to determine each individual's sex offender classification. Just like, and again, our system gives more rights to any others, to sex offenders than any other state in the whole United States. I mean, like Matt, a good example is New York and New Jersey. In New York, you cannot request a termination unless you've done it as a level 2, unless you've been on the registry for 30 years. Every 3 years, an offender in our program gets a right to ask for a reclassification or a termination.
But if that was, okay, I accept that, but obviously, somehow or another, New York and New Jersey have a whole lot different skewing of low, moderate, and high, much more in the low and much less in the high. So the fact that they have fewer rights, it just doesn't seem like it relates.
Well, I think you got to look at the statute. Again, they do have fewer rights because it's based on a numeric system. They can bring in very little evidence to even lower it then. There's a good chance that the level 1s shouldn't be on the registry. The level 2s should be level 1s. So it looks like if you read the studies, they specifically say New York and New Jersey do not adequately predict sexual recidivism, which is indicative of the fact that they're over-classifying sex offenders.
I could ask one more question, unless others have them. Does internet dissemination, in your view, change the balance?
That's my question.
I don't say it changes the balance because, again, you know, and I don't want to be facetious, but you have to be living under a rock for the last 20 years not to know if you commit a sex offense, you're going on the registry, and that there might be possibility of internet dissemination if you're a level 3 and now as a level 2. I think the better course is don't commit a sex offense. I mean, at some point, you have to protect
The better
the
course
public.
is to be more careful about who is required to report on the internet, particularly now when you know that that means essentially lifetime reporting of the fact that you have committed an offense for both level 2 and level 3, which comprise the bulk of those who are categorized in Massachusetts.
And the point is that there's no evidence that we are not being as careful as possible to do that. We balance, the system we have is the best system you're going to have. Not only do we balance in our hearings, and we try very hard to balance the rights of sex offenders with the public safety, but we have an automatic review to Superior Court where a Superior Court judge can oversee it, automatic appellate court review, and every 3 years they have a right. Since 2010, almost 200 sex offenders have either been terminated or allowed to have their classifications lowered, and out of that, half of them have been in the last 3 years when we implemented the 3-year process for reclassifications. This isn't a New York system where it's a lifetime or 30 years on the registry, or New Jersey where it's 15 years. We are trying to be in the middle.
Altogether?
Excuse me?
Don't we have 13,000 people registered altogether?
Yes.
So 200 out of that?
And I think that that is a fair and accurate amount because, again, we're dealing with people who have committed serious sex offenses. And in that sense, there's a public safety issue.
All right, thank you. And we'll take our morning break.